Good morning. Today, on the morning of October 7th, 2020, the first argument we will hear is case 18-956, Google versus Oracle. We will start by hearing Joshua Rosencrans for Oracle.
Thank you, Your Honor. Google's entire argument is based off of the idea that technological code is not protected the same way as other copyrightable items. No court has found fair use or upheld a fair use verdict where a copyist copied so much valuable expression into a competing commercial sequel to mean the same thing and serve the same purpose as the original. Google conceded the purpose and the meaning of Oracle's code, and Google's code are the same. There was and still is a huge market for declaring code. Other major companies like IBM and SAP were paying a lot of money to license just the Sun declaring code precisely because it was created. And throughout this litigation, Google never denied this. If this court holds that a jury may conclude that copying and declaring code is fair, it will encourage copying, create legal uncertainty, and disseminate the business model which a lot of companies depend on. And this undermines the very incentives that copyright was designed to promote.
Thank you, Mr. Rosencrans. You seem to be arguing for more than declaring code. If I'm right there, do we need to decide on more on that?
No, Your Honor. All this court has to decide is whether the declaring code was original. For purposes of copyrightability, it was, and for purposes of fair use, whether it was fair to copy the declaring code.
Thank you. Now, Mr. Goldstein, what is your argument?
The merger doctrine resolved the copyrightability question in this case. Specifically, under the merger doctrine, there is no copyright protection for computer code that is the only way to perform those functions. Oracle has a copyright to the computer code in Java SE, but not a patent. Thus, the public, not Oracle, has the right to Java SE's function, and Oracle cannot leverage its copyright to create patent-like rights. Here, Java software developers have the right to use certain commands to create applications for Google's Android smartphone platform. But to work, the commands require Google to reuse an exact set of declarations from Java SE, like a key that fits into a lock. Because there are no substitutes, Oracle is claiming that exclusive right not only to what the code says, but also to what the codes do. This is not a copyright, it is a patent right.
Thank you, Mr. Goldstein. Now, Mr. Rosencrans again.
We are suing Google for both patent infringement and copyright infringement. Google and its developers lifted software routines in our Java programming language to create Android, the operating system that Google says powers 2.5 billion mobile devices worldwide. We are seeking $9 billion due in monetary losses.
Objection, Your Honor. Java's functionality is a domain of patent rather than copyright. Granting copyright protection in the declaring code would effectively be granting Oracle a copyright in Java's functionality, which is wrong because functionality is a patent right. The script is the basis of how this platform functions. Therefore, it falls under patent, meaning that the copyright wouldn't be an issue here.
Thank you, Mr. Goldstein and Mr. Rosencrans. And now to the question of fair use. Mr. Rosencrans?
As I mentioned prior, no court has found fair use or upheld a fair use verdict where a copyist copied so much valuable expression into a competing sequel to serve the same purpose as the original. Finding that Google's use was fair would lead to rampant copying in the software industry and undermine the incentives for creating new and innovative works.
Based on precedent, transformative use had something new, with a further purpose or different character altering the copyrighted work with new expression, meaning, or message. Was Google's use not transformative as we sought to expand the use and usefulness of Android-based smartphones? If you argue against fair use, you are giving Oracle a monopoly over declaring code.
Thank you, Mr. Goldstein and Mr. Rosencrans. This marks the end of our arguments in case 18-956, Google versus Oracle. Now the court will present its majority and dissenting opinion.
I, Justice Thomas, along with Justice Alito, felt that Google's use of Oracle's Java was not fair use. We believe that Google only passed the first factor of the fair use test and that Oracle did not spend a great amount of time and money to create its programming code, only for Google to come and copy it. We believe this act violates the Copyright Act and that the declaring code should have been copyrightable. Thank you. I, Justice Breyer, am here to deliver the final opinion of the court. When it came to the determination of fair use in the case of Google v. Oracle, we came to a 6-2 decision in favor of Google. We decided that, assuming the declaring code was copyrightable, the way that Google used this code constituted fair use and violated no copyright law. The test that we used in this case was the fair use test, which relies on 4 factors. 1, the purpose and character of the use. 2, the nature of the copyrighted work. 3, the amount and sustainability of the portion used in relation to the copyrighted work as a whole. And 4, the effect of the use upon the potential market for or value of the copyrighted work. We believe that since the code was used to make something new and important, and that only a small portion of the total code was used, the use was fair. Furthermore, according to evidence brought forth in the lower courts, Google's use of the code does not have a great effect on Oracle, as Oracle has not been successful in entering the cell phone market, and that Google's use of the code would actually benefit Oracle because more people would learn about and use Java. Therefore, we have decided that Google's use in this case passed all 4 factors of the fair use test and violated no copyright law. Thank you.
Hey, Tim.
Hi, Elon.
Thank you so much for sitting down with me today to discuss the Google versus Oracle case. As the CEO of SpaceX and Tesla, this case is of substantial interest to me. Electric car sales are always growing exponentially, and coding is actually how we make sure our cars have all the features that many people have come to love and expect, such as apps, conditioned interiors, and don't forget the self-driving aspect. I personally value the human mind and am motivated by idealism, so I believe it is completely unrealistic to keep fundamental information from each other that could benefit everyone, because who knows, it might lead us to space. Further, sharing knowledge can keep us safe. I personally would love to continue to create codes that progress our society and each other's safety, and I know I'll be sharing it with anyone who would care to have it. I am thankful that Google won this case because it is an outward expression of our society coming together to move forward.
I agree with you. Being CEO of Apple, coding is a large part of what we do. Without the ability to use our code across other relevant platforms, we would run into issues on a day-to-day basis. But this case is a victory for our programmers and developers because it gives them the ability to use their experiences and understanding of software interfaces on other relevant platforms without the possibility of copyright infringement. By the court ruling the case a fair use case, it helps big businesses benefit from it, and the creative nature of society can continue. The use of Java by Google was consistent with the creative progress that is the basic constitutional objective of copyright itself. At Apple, we are creators and innovators, so the ability to continue to do so in a fair and healthy way is crucial for our company. This case was able to give us more comfort in knowing that we are doing good work and aiding in the creative progress of business and society.